Welcome to Munro TV. My name is Rowan, and today I'm going to be discussing an interesting topic that has come up of late within the Road Accident Fund domain. It's this matter of domestic assistance, whether it forms part of the Road Accident Fund undertaking or whether you can claim it as a lump sum as part of the claim for damages. The case that has come up is the matter of Cakwebe versus Road Accident Fund. It was decided on the 26th of October 2016 in the Eastern Cape High Court. And the issue in that matter related to the ambit of the Road Accident Fund tendered undertaking in terms of Section 17(4)(a) of the Road Accident Fund Act. Let me just read that section for you. It says this: where a claim for compensation includes a claim for the costs of the future accommodation of any person in a hospital or nursing home, or treatment of or rendering of a service or supplying of goods to him or her, the Road Accident Fund is entitled to furnish the third party concerned with an undertaking to compensate that third party in respect of the costs that they have incurred, or provide funds directly to the service provider. And then it has this little phrase which really is the pivot upon which this case turns. It says, in accordance with the tariffs contemplated in subsection 4, big letter B. Now subsection 4B is basically says that the costs must be based on the tariffs for health services provided by the public health establishment. Now the plaintiff in this particular matter, Cakwebe, included the costs of the future employment of a domestic assistant based on a case in the Free State Division that was decided in February 2016, the case of Mfarime versus the Road Accident Fund. And in that matter, the court held that the cost of domestic assistance does not fall under the classification of health services or expenses in terms of Section 17(4)(a) and 4B, but actually constitutes a loss in terms of Section 17(1), and a loss under Section 17(1) is a lump sum loss. So this means that the capitalized value of the cost of an assistant could be domestic, it could be a handyman, it could be gardener, can actually be calculated by the actuary as part of the damages claim. Now in this Cakwebe matter, the Road Accident Fund argued that Mfarime was actually incorrectly decided, and that in fact in the matter of Ndawonde versus the Road Accident Fund, which was heard in the Pietermaritzburg High Court, that court also decided against the rationale within Mfarime and did not allow the costs of a caregiver to be capitalized. By the way, the references to all these cases can be found in the little excerpts below our video, so be sure to check them out. So let's move on. The court in Cakwebe says that the learned judge Mfarime basically made two mistakes. The first one is that he does not address the underlying purposes of Section 17(14)(a). This is what the court had to say. The interpretation in the Mfarime matter is confined to a reading of the words employed in the section without consideration of their contextual meaning. The second problem that the court in Cakwebe had with Mfarime was that what was absent from the judgment is any engagement with the legislative history, in particular the nature of the introduction of tariffs in Section 17(4)(b). So the court then says, well, the question that has to be asked is, what was the purpose of the introduction of these words? And the words are this: in accordance with the tariff contemplated in subsection 4B. In accordance with the tariff contemplated in subsection 4B. So the court said in Cakwebe, either these words qualify all categories of future loss that a claimant can experience, or these words refer to how much liability the Road Accident Fund has in respect of services that are regulated by health service tariffs. So those are the two options that the court looked at. And so the court said, well, the first place to start is to look at Section 17(4) big letter B, where they believe that the words that are there, the words are this: the liability of the fund regarding any tariff contemplated shall be based on the tariffs for health services. So what they say in the plain reading of those words really refers to the latter interpretation that I've just mentioned. That really says, referring to how much liability the Road Accident Fund has in respect of services that are regulated by health services tariffs. But the court goes on to say, if you take the former interpretation, in other words, those words in accordance with the tariff contemplated in subsection 4B, refers to all categories of future loss that a claimant can experience. If you take that interpretation, then you are restricting the ambit of section 17.4a only to health services, which he says in the judgment would be contrary to a long-established interpretation of the section and its legislative predecessors. So the effect of such a restrictive interpretation would be, in the words of the court, to leave all other recognized and accepted categories of future loss to be determined as lump sum payments of patrimonial loss, subject to the vagaries and uncertainties that come with experts actually trying to predict what the future liability looks like. So the court said the reason for this undertaking was to take out all those uncertainties in the system when it comes to the provision of future services, as well as give the claimants a measure of security of access to those services that paying a lump sum does not provide. So the conclusion of the court in Cakwebe was that had the legislator intended as a significant and far-reaching amendment of section 17.4a as suggested by the Infirimi judgment, then it would have affected it in clear and unambiguous terms. The court said this the legislator had not done, and therefore it concluded that the Infirimi case was not correctly decided. The court also refers to a number of other decisions, mostly in the Eastern Cape Division, that upheld the undertaking for services that are not health services, and those can also be found in the excerpt below this video. So until a higher court decides on the matter, you still have to proceed with your case where a domestic help or service is required. And the question is, well, how do you instruct your actuary? The best thing to do is that if you want your actuary to quantify the domestic assistance as a future lump sum, then instruct your actuary to do so. In other words, if you want them to proceed in terms of the Infirimi judgment, then that would be part of your instruction. Great, I hope that's been helpful. If you have any questions, please feel free to email us, and always remember to click subscribe. Thanks.